CEO of the Nova Scotia Human Rights Commission. And I am very pleased today to be hosting our panel discussion this afternoon as we imagine the future of human rights through two-eyed seeing. Our discussion is being recorded and it will be available afterwards through the Human Rights Commission website and also on our YouTube channel. So I would like to begin by acknowledging the territory from which I and many others are gathering today for this discussion, although virtually. As a descendant of Irish and Scottish settlers to this territory, I acknowledge these lands as Mi'kma'ki, and I acknowledge the Mi'kmaq or Olnu people as the stewards and keepers and protectors of this land. And I acknowledge the treaties of peace and friendship that form the basis of the relationship between the Olnu and settlers to Mi'kma'ki. And on Human Rights Day today, in particular, I want to recognize the ongoing injustices that are experienced by Indigenous people in Mi'kma'ki and across Turtle Island. And specifically today, we're thinking about the many missing and murdered Indigenous women and girls and Two-Spirit people. I am always so grateful for the many knowledge keepers or better knowledge sharers of Mi'kma'ki for their seemingly endless generosity in sharing their wisdom on so many different topics. And today's discussion is just one example of that generosity. So each year we commemorate Human Rights Day on today, December 10th. Which marks the anniversary of the date the Universal Declaration on Human Rights was adopted by the United Nations in Paris in 1948, which at that time was really a groundbreaking global commitment to protect the rights of all people and to establish a common understanding that all people are equal in dignity and in rights. Now, earlier this week, December 3rd through 10th was actually proclaimed Nova Scotia Human Rights Week for the first time ever by Premier Tim Houston. And this was in honor of the 75th anniversary of the UN Declaration on Human Rights. The Nova Scotia Human Rights Commission and our partners around the province have been honoring this Nova Scotia Human Rights Week with a series of educational events. Pardon me. And on Friday of this week, we honored a number of human rights champions with the 2023 Human Rights Awards for their advocacy and social justice work. And today's discussion is the final event in our week. And we have some big and important questions to contemplate together this afternoon. So let's get started by introducing our panelists. John R. Sylliboy is Olnu Mi'kmaq from the Millbrook First Nation. He is one of the co-founders and executive director of the Wabanaki Two-Spirit Alliance, which was established in 2011. The Wabanaki Two-Spirit Alliance helps to build support and awareness of Two-Spirits in Mi'kma'ki and throughout Canada. John is also a researcher, a consultant, and a policy analyst for his own company, J.R. Sylliboy Consulting, where he works in social and cultural development, health and education policy, and research for Atlantic Indigenous communities, especially for Two-Spirits and Indigenous LGBTQ. John, it's a pleasure to have you with us this afternoon. Walalan, thank you for being here. Our other panelist, Tuma Young, was born in the Aduduwich clan of the Abeligomooch clan and is a member of the Eskasoni First Nation. Along with John, he is one of the co-founders of the Wabanaki Two-Spirit Alliance. He is the first Mi'kmaq-speaking lawyer in Nova Scotia, and he teaches at Cape Breton University. Tuma also runs his own private legal practice, and he is on the executive of the Nova Scotia Barrister Society. Tuma has been working to make Olnu communities welcoming and to celebrate Two-Spirit people for many years. Walal Duma, thank you for being here as well. For folks who are joining us online, welcome. I'm happy that you're able to join us for this discussion. The Q&A function is available for anyone who wishes to ask a question of our panelists. So please, if you have something you'd like to contribute to the discussion, please use that Q&A function. We may or may not have time to get to all of the questions, but we'll certainly do our best. So this discussion today is about embracing the 75th anniversary of the UN Declaration on Human Rights as an opportunity to reflect. I referenced just a moment ago the gratitude that I feel for the teaching and sharing of wisdom that I've received over the years from many Olnu knowledge holders. And if we understand and respect the history and the context of this place of Nova Scotia, I think it's incumbent upon us that when we have to grapple with big questions or complex problems, that we embrace Mi'kmaq wisdom, and also the wisdom from the African Nova Scotian community, who we know has been present here in these lands for over 400 years. And I'm always struck by the similarities between the wisdom that comes from those two communities. If you take, for example, the Afrocentric principle of Sankofa, which tells us that as you look ahead to the future, you must also consider the past and, in fact, bring the past with you. And Sankofa always reminds me of the Olnu teaching of looking ahead 7 generations, but also looking back 7 generations. And in some ways, I think that's the discussion that we're having today. That's the conversation. In terms of our human rights framework in Nova Scotia and Canada and around the world, we have 75 years of history behind us. And so now we pause and we consider the future of human rights, hopefully with a deeper respect and understanding of the wisdom that comes from sources other than Western ideologies. And today we're approaching the topic specifically from a two-eyed seeing perspective and drawing on the wisdom of two-spirited Olnu, bringing that two-spirit perspective to the discussion. So I'm keen to get started, and if I could, Duma, I'd like to start with you. What can you tell us about two-eyed seeing?
Okay. Well, two-eyed seeing is really Etuaptmumk. It's called Etuaptmumk, and it's basically looking at the same issue or the same perspective the same issue from 2 different perspectives. And it was first developed or reclaimed back at Cape Breton University by elders Merdina Marshall and her husband Albert Marshall. And it was originally brought in to address getting more students into STEM, which is science, technology, engineering, mathematics programs. And Albert and Merdina brought it forward and said, that Illinois, we had our own STEM, we've had our own math, we had our own sciences. And from there on, we brought in traditional knowledge into the courses and the programming there. And from there on, it has grown, and it's now applied in many disciplines, in many approaches, and in a number of academic institutions, and not just in academic, but in NGOs and in governmental institutions. And some people are also doing it and applying it in their daily lives too. So in a nutshell, that's what Etuaptmumk is.
So Duma, when you say it's about using different lenses or seeing things from different perspectives, what would those perspectives be?
Well, the original perspective is that we are looking at Western science from the Western science academic disciplinary processes and looking at the same thing through Ulnu science or Ulnu Indigenous knowledge. To give you a good example, in the field of botany, the botanists usually identify a plant through the flower, Each each plant has a flower that is like almost like a fingerprint. It's identifiable through. But for Ulnu people, we identify the plant through its jabisk, which is the root. That's the part of the plant that we use. And to come up with the whole knowledge of the particular plant, I was able to take in indigenous knowledge of locating the plant through the roots, and using Western knowledge of locating the plant through the flower. So to bring them together, you get the complete picture, so to speak.
That example really helps to kind of bring the concept to life. Thank you for that. So two-eyed seeing is one of the kind of foundations that we're using for the conversation today, really looking through that lens. And of course, anytime we enter these conversations, we're coming to it from our own individual identities. And so the other key piece that I think it's good for everyone participating to kind of understand and get a sense of is this notion of two-spirit. So John, I wonder, could you speak a little bit about what it is to be two-spirited?
Hello, everyone. Well, here it's just noon. Good to see everyone. At least the 4 people I see on the panel here. I'm sure there's more people behind the screen. Yeah, so there's two points I want to add on to what Tuma had said about Etuaptmumk. Then I'll explain like how it relates to, or how it led to how we're looking at two-eyed seeing. The other, I think a lot of folks in the published world, at least, think that Etuaptmumk or two-eyed seeing is only coined back in the late 90s and 2000s by our elders, when the foundation of Etuaptmumk has always been there, like how we view the world from those various perspectives in this case. And we know that strengthened that evolutionary part around how Ulnu, or Mi'kmaq in this case, have always incorporated ways of knowledge to look at and address different things as we go through life. And through that process, when European knowledge started establishing its roots in our area, in our territories, we Mi'kmaq had to also evolve with that process of that impact of knowledges being introduced, either through spiritual understandings of who we are and how we practice spirituality, for example, and even how we look at our identity and how we started building relationships with these new peoples in our areas. So the evolving nature of those Western and Indigenous perspectives for Ulnu was a way of surviving. And so we had to use these ways of doing and knowing and even living by incorporating the two ways or other ways, right? And so that really strengthened it during that part. But elders Merdina and Albert always knew that and then put it into the English words two-eyed seeing. But Etuaptmumk is always something we know. Etuaptmumk, and the concept of that and how we use that word. In looking at two-spirited context around being Ulnu and identity and exploring what two-spirit is, we had to look at what two-spirit is from the context of the word in English and where it came from in contemporary language use with other nations across not only Canada, but in Turtle Island, how people were looking at two-eyed seeing, two-spirit, the identity of two-spirit. It was coined in the 1990s, but then again, this concept of being two-spirit has existed for many, many, many generations amongst many nations. So the understanding of gender identity and or sexuality and how they may intersect or even separately develop as an identity, part of your identity as Indigenous people, that intersects their sense of spirituality is part of our ancestry of identities in our nations around Turtle Island. So some people had specific words for two-spirit, and other nations had been impacted by colonialism when these words were, fallen out of use or they weren't used anymore because of different impacts from historical, religious, or Christian faiths coming in impacting how we look at identity and spirituality altogether. So in Mi'kmaq, And through our, our conversations, Duma and I even started asking our community, what is Two-Spirit from Mi'kmaq perspectives or Olnue perspectives? And then we started analyzing this through language, through our ancestral knowledge around being and living, and through knowledge of identity. And what are those sources of identity as well? So we started looking at understanding better, like our identity has been impacted by this evolving way of being, as two-eyed seeing evolved and influenced our way of thinking. But also we've seen that we know that our two-spirited identity as Olnuk has always been there, but we then started to have to shift and understand, okay, in a two-eyed seeing way, we know that gender is seen this way as a Western framework that's very linear, somewhat binary even, and and it can be something that's sort of looked at as stages of development. And when we started looking at our identity and our identity as two-spirit people, then we started understanding that identity is very fluid. It's in flux quite often with your identity as being Olno. And it's something that's evolving over time without, established markers of time. You can't look at it in stage development like a biomedical process. It's something that evolves over time in nature, in space, and in place. And so our identity, we understand it more as something that's ongoing. And so that helped us understand from a Western and Olnue knowledge how that is, because we've been influenced by both. And in fairness, we have to look at it from those perspectives. But really, it's really strengthening how we go back to our sources of knowledge to understand then what that means for identity, for rights, and for, moving forward, and how we incorporate that into an educational model so that our young people and our elders and people in leadership will understand what that looks like.
John, I've heard Two-Spirit being described as masculine and feminine spirit kind of coexisting within an individual. What would you say about that sort of definition of Two-Spirit?
That's a very simplistic definition. I mean, that's been the narrative that's, in English language, we often want to find the easiest way to say something about something. And so that phrase is the one that's taken over the narrative, that it's the male and female. That's one part to it. Other parts to it include, it may be about gender and how that process evolves for trans people, for example, but that's not necessarily involves the sexuality part of who you are and your identity in that sense. You don't become gay as a 6-month-old baby. That evolves into your identity during your lifetime, right? But then you also know that your identity may be misidentified because of your circumstance of who you are, and then you become who you are, whether it aligns well with your gender identity, as a construct or something that's really biological. So those things are very important to understand. So it can't be just a simple male-female. That's a very linear ideology around identity. So it's quite reductionist in that sense. But then that's easy, though. That's easy to understand for people, and it becomes a very romantic notion. And then people often say, well, I do have a sense of femininity on my side, or a sense of masculinity on that side, and I would negotiate with those things. That may be true for a lot of people, but it's not the actual part to it. There's more elements to that. If we had a word in Mi'kmaq for like we do for Etuaptmumk, Etuaptmumk being Duma would understand. We know from our collective consciousness what it is. We don't have to write a 7,000 word paper to explain it in the English sense. If we said the word Etuaptmumk, we would know what that means. And we're trying to rescue that notion of identity as that two-spirit person in Mi'kmaq, so because it would make it clear. What we sometimes say now is that if Duma's two-spirited, and then I know people know Duma and they know who he is and how he is, I'll say, a person like Duma. I'll say that, and they'll understand that, Duma is a two-spirit person who's an educator, a researcher, a knowledge holder, and, legal expert, and all these things. They would understand the whole concept of that identity, who Duma is, without having that word. But once we have that word, like that word Etuaptmumk, it just through collective consciousness, we can explain that, but that's not easy in English languages. So we have to go back to the source of the knowledge to get that right.
Very, very helpful. Thank you. So having taken just a quick look there at the notion of two-eyed seeing and of two-spirit identity, I want to start thinking now a little bit about human rights and the human rights framework that we have in Nova Scotia and Canada. I mean, it's similar in many parts of the world. Tuma, I'm going to come to you for this question. As a two-spirit lawyer in Mi'kma'ki in 2023, what ways do you see our human rights framework working or not working for Ulnu?
Well, oh, excuse me here. Human rights discourse has always been an interesting conversation and institution here in Mi'kma'ki, and I'm going to say Mi'kma'ki, primarily Nova Scotia. If you trace back to the history of it, there's been multiple layers. And, Joe, I was just thinking about it as you were talking about it. We were thinking about from the Nova Scotia context and from the Canadian context, but there is multiple other contexts, these layers that even John referred to from the individual two-spirited person layer and even identity. Even in the human rights context, there are multiple layers there. You also have the international concepts of it, and even from the international law. And we're also, looking at it from the Ulnu concepts of human rights. So it's not just, the Canadian government states perspectives on it. But we often frame that discourse in that sense. When we look back at the history of Nova Scotia human rights and following the changes and adaptations, early on, I believe it was in 1990s that there was a huge movement to bring sexual orientation as a protected area under Nova Scotia human rights. I was part of that movement, even though I knew that because of the jurisdictional areas, that would never apply to two-spirited people in First Nations communities. Those protections could not apply. And even when the Canadian Human Rights Act was changed in, I think it was 2007, 2006, to remove that particular section exempting First Nations communities from, or the Indian Act of it, then even still, you still have jurisdictional issues, and that when we're discussing human rights discourse from an Ulnu perspective, we don't go into jurisdiction first. We'll say, well, what is the right thing to do here? But if we're talking about it from the Western perspective, often because we are First Nations and there's this legal space that's unique, we often have to look at the jurisdiction first before we even get to what should be done. No.
Tuma, before you continue, can I interject just for 1 second? For the benefit of the listeners, would you just speak a little bit to this jurisdictional issue in case folks aren't aware of what's meant by that?
Okay, the Nova Scotia Human Rights Act applies primarily to Nova Scotia, with the exception of federal lands, which are reserved lands or First Nations communities, or anything that touches on, or provincial laws of a general application that apply unless they touch on the Indian or Indianness of the person, because of the division between the Constitution of Section 91, Section 92, the division of powers. Whereas there's provincial head of powers under Section 92, and federal head of powers under Section 91. And the federal head of powers under Section 91, subsection 24, gives the federal government the authority to legislate over Indians and lands reserved for Indians. And I use that phrase in that legal context, that term Indians, because it's still that's where you get the Indian Act. And for many years, the Indian Act contained the provisions exempting itself from the auspices or the view from the Canadian Human Rights Code. And also because it was a federal act, and the provincial Human Rights Code could not apply in many different circumstances. So, if there was an example of a discriminatory event that happened in a First Nations communities, regardless of who the actors were, Nova Scotia Human Rights Commission or the tribunal or the jurors would not have any jurisdiction in there. So often the first question that when people would go and make a complaint, the first question that the Nova Scotia Human Rights Commission would have to ask is, do we have jurisdiction here? And sometimes that would get a little confusing, and sometimes you would go through the process and people would expect that there would be some sort of a recourse or remedy here. And after about 6 months to a year of going through the process, realizing that there is no jurisdiction here, and then the person would have to be told, I'm sorry, we don't have jurisdiction here, that you would have to go to another area, the Canadian human rights area. So that invariably leads to a lack of trust in the process. So, and this is not uncommon in First Nations communities, both in North America, even if you go to many reservations in the United States where there's a domestic sovereignty issue there. And if there's, I'm going to use the criminality aspect of it. If there was a crime committed, because of the nature of how laws were applied and changed, you may have a checkerboard approach to it. And often the first question has to be asked, who has jurisdiction here? And based on that, who can do the investigation? Whereas people would say it doesn't, most people who are the subject of a potential human rights violation would say, doesn't matter who has jurisdiction, I need redress or recourse to it. But when they don't have it, it leads to a erosion of trust in the institutions. So that's where, for those who may not know, we have that problem of jurisdiction here. Often discrimination complaints that are launched in First Nations communities have to go through the Canadian Human Rights Tribunal, not necessarily to the Nova Scotia Human Rights Commission. That's not to say that the Commission has not taken on some cases where it is, the jurisdiction event or hasn't taken carriage of the file. But sometimes that's more in the case of when non-native Indian communities were had their discrimination things. So the basic point is that before we go through the process, we have to determine who has jurisdiction, and that's a question that has to be done first. When you're dealing with Indigenous people, often that's the first question, and that's the difference between looking at it from non-Indigenous people. They don't have to go through that process first because of the unique nature of our Canadian federal state.
Mm.
Yeah, thank you, Tuma. Just want to remind folks that the Q&A function is available as well. If you do have any questions that are kind of percolating from the discussion, please feel free to pop those in there. We will have some time near to the end for us to look at those questions from folks.
And I just want, Joe, I know that you interrupted me. I was going to go back to the first thought about, and so over time, we have all these multiple layers of human rights acts, legislation, treaties, etc., type of thing. But we've never really discussed or thought about it from the UNO human rights institutions or their codes or their what we would call Debludahan, the laws. So and often we think about our rights from a collective perspective. And that's not to say that there is not an individual rights discourse. In fact, that's often was the source of tension between Indigenous communities who were trying to assert self-determination and self-governance, and over the application of a human rights discourse that was rooted in individuality or an individual's rights discourse, and without being able to take into account the collective rights of the people. And so since the 1970s, you've had, that's not to say that human rights processes have not been successful in advancing or moving the needle ahead. They have been for individuals, but often not necessarily in the terms of the collective rights, which are probably enshrined in treaties, in Aboriginal treaty rights, and so the collective would want to assert these, but really it's very difficult to advance a collective rights complaint process through either the Nova Scotia Human Rights Commission or through the Canadian Human Rights Commission. That's not to say it hasn't been done. I mean, we just recently saw the successful thing of the Children in Caring Society through the Canadian Human Rights one, and the most famous name associated with that is Tindy Blackstock. But when we look at, often the wins have been at the other levels of human rights, which is either at the international one or at the UNO one. And that's not to say that the Nova Scotia Human Rights Commission hasn't been successful. They have been very well, but we have to think about it from the Etuaptmumk perspective. We have a collective rights discourse, individual rights discourse, jurisdiction, legislation, the Canadian state. It's a multiple space that we have to fully comprehend and look at in order to ensure that people who the folks who go through these processes are given an equal opportunity for redress or recourse, or that their stories have been heard, and over our past history, we think about specific instruments that have worked very well, like, for example, the International Labour Organizations, ILO 169, the Indigenous Compact there at the United Nations. That was in place, in existence, after the United Nations were brought in, and that has resulted in Indigenous communities asserting their rights through that way, rather than through the Human Rights, United Nations Human Rights Declaration. It was often through the ILO 169. You also had, individuals asserting that claim for all or class action. For example, retired Senator Sandra Nicholas from Tobic, she took her claim to the United Nations at the international level, and brought her claim of human rights violations related to her status, when in the Canadian context, the Canadian Bill of Rights could not do anything about it. And in the Supreme Court of Canada and our court systems were unable to provide that recourse or redress. So she went outside and went into the international level. So in some ways, these processes work, but we never really managed to bring them back to the UNO processes of how do we look at these through our treaties, or through our Aboriginal treaty rights, and through our Deblo Dahan. Our approach to it would be let us do the right thing, right? Which is how I think we need to have more research, more thought, and more support as to how we can bring this up to a workable institution.
Thank you, Duma. John, how would you build on what Duma has set out there?
It's so interesting how we look at rights, period, and the influence in history around what individual rights meant, collective rights meant, the rights of states, and the rights of international law. And in this whole process, it's always been very human-centric. It's always been Occidental or Western centric. And so we have to remind you that Indigenous people were even recognized as humans, let alone be under the concept of human rights. But we were always there as, the treaties that we had, the peace and friendship treaties and the covenant chain of treaties with the Crown, that we were equal to each other as nation to nation, and of that represented our sense of nationhood, from the individual to the collective, to the community, to the nationhood, and that collective tribal consciousness as who we are. And it eroded over time, obviously, in our area here. But we also understand that because human rights have been the result of conflict, it's always been the result of war and a result of some sort of erosion of relations, that those things came out. But in the balance of what rights are, it always favored the human. And from our perspectives, in Ulnui Das and Ulnuwe and Ulnui, we understand that we have a sense of stewardship and that inherent right to understand that it's not only human. The rights of us have to be equal, if not be encompassing of the rights of everything around us. And that's what's disbalanced the situation ecologically and has eroded our ecosystems quite tragically, actually, around our areas. You know, all the things that we're dealing with these social illnesses and the imbalance in the management of resources is because we haven't respectfully addressed the rights equally of all things that we consider Mindu or spirits because we don't just look at it. We can't just look at it as like all of us as humans, like we see in this screen. That's what's wrong with the rights and inherent rights of those spirits. We're not considering all of them because we're heavily considering only the human aspect of those rights and humanity versus what else represents all of that. And I think if we went back to that understanding that the rights of what we consider right in the world rather than what's wrong in the world is a lot of the deficit language around why human rights exist to begin with. And that sense of deficit language around that, instead of building around language that builds with justice being for positivity rather than just a causality of something that's been done wrong. And if we flip that around, if we looked at it from an Ulnuwe perspective, then we have to look at it from that ecosystem perspective where we consider everything at equal stance of right. And if we can do that, then we can try to balance what's wrong with the rest of, the economical, the scientific, all the other parts that we're trying to deal with when it comes to that. And I think we have to expand our understanding what rights are then. We can't just heavily rely on, and this is where Etuaptmumk is important, because Etuaptmumk engages our indigenous ways of being and living and understanding our way around our world, and how we try to use rights to, represent all of that perspective rather than just leaving from the human rights perspective and working outwards. We approached it with an equal balance of, the indigenous with the Western frameworks around what's right with rights, then we can approach it in a Etuaptmumk way, right? That's important.
And just as I'm going to jump in, and I know there's a question in the chat that I'll get to in a second, but I just want to build upon something here John was saying. When looking at Etuaptmumk in context of human rights, one of the things we're missing is, what has been called for in many inquiries, many commissions, many recommendations. There's a ton of them, and most recent ones was Truth and Reconciliation Commission and the Murdered and Missing Indigenous Women and Girls calls to justice and calls to action there. Is that we need to bring in Ulnuwe Debludan or indigenous laws to how we're going to be seeing things. So in some ways, we need to bring in for the future of the Nova Scotia human rights is that I see that we're looking at it from the Nova Scotia Human Rights Commission's Human Rights Act, the processes, but we also need to bring in Ulnuwe Debludan to that process too. And it can be done. I do it in my legal practice every chance that I get, I bring it in. Just the fact that we're bringing in language is one aspect of it, but also that these rights self-contained responsibilities and obligations,
Mhm.
and that these are to other life forces, not just human ones, but to other life forces. And because our first treaties were not with other humans, they were with other life forces,
Mhm.
the trees, the animals, etc. We have treaties with those. So with treaty rights come treaty obligations to these. And so that's I just wanted to touch base on. So for future of Nova Scotia Human Rights Commission should also, we need to bring in Ulnuet Ebludan into the work it does, the presentation it does, the processes it has to permeate through it. And that's where you have Etuaptmumk, you would have a process that brings in multiple perspectives to get to the right answer or to do the right thing.
Mhm.
Now, the question that was asked in the chat, and I know I'm just going on, Joel, I'm sorry, it says, this question is for Tuma. What place does Jordan Principle has in addressing the jurisdictional conundrum that the Canadian state system and its legal framework has placed on Indigenous people's access to human rights justice in Canada? So I'm just going to explain Jordan's Principle a little bit. There was a young child, I believe it was a Manitoba, that was had suffered illness, and this jurisdictional battle over who has the authority to provide care or whose jurisdiction is this has been fought for many years in many different areas, like between the Canadian federal state and the provinces, each of them not wanting to take full responsibility for services it can provide. Under the Canadian state, the Indigenous Services Canada has the authority to provide these services or through non-insured health benefits. The province has jurisdiction and authority to provide medical services. Many years in the past, the provinces would say, and I use the term again, Indians are federal health responsibility. We have no jurisdiction there. We don't want to spend any money here. And so as a result, health services for First Nations people was at non-insured health benefits, which did not provide the same level of services that were provided at the provincial level. Until this, Jordan was the name of the child who was sick and could not leave the hospital. And there was a jurisdictional battle between the province and Canada as to who was going to pay for these health services. Both of them were pointing at each other, and refusing to pay. And as a result, the child Jordan died outside of his home community. His family wanted Jordan to come back to the community and have those services provided in the First Nations community, but both the province and the federal government refused to pay. And as a result, the child spent all of its life in the hospital without being able to go back to his community after those services. As a result of a court battle, the courts decreed Jordan's Principle, which said it doesn't matter who is the first to be contacted. They will pay first, and then the battle over paying after will occur later on. But these services will be provided. So today, if Jordan was still alive and had to go home for healthcare services, those services will be provided either by Canada or the province, and then they will argue amongst themselves later on. But they will be provided. Because of that, and it was also linked in with the Children in Care Society lawsuit that was the Canadian Human Rights complaint that was filed with the Canadian Human Rights Commission by the Children in Care Society over the unequal provision of services of children who were taken into care under the Children's Aid Societies or the child welfare processes. First Nations children were denied the same levels of services that non-Indigenous children outside of the communities were receiving, or that the quality of these services were different. Cindy Blackstock was the major proponent of this, and she led the fight in this, and she had the tribunal rule in her favor. And then, but it was getting the Canadian state to implement the whole the order from the Canadian Human Rights Commission, and it took 12 non-compliance orders from the Canadian Human Rights Commission. And at the last one, the CHRT finally ordered Canada to pay compensation in the amount of up to $40,000 per child. And that's when Canada took a notice of it, and then they filed an appeal and filed for a judicial review of the decision. They lost at the federal court. It was appealed to the appeal court of federal court. And as it went through the federal court appeal process, they reached a settlement. And the settlement between all the parties reached a settlement, which also included Jordan's principal. There was another class action lawsuit that was launched for a number of law firms outlining the inequality of these health services that were provided or not provided to children in care and to Jordan's principal. And this was just recently settled to a class action compensation claim of, I believe it was $40 billion. Yes, that B with a billion. And out of that, 20 billion is to be used for services and also for Jordan's principal to provide for that, And again, the principle permeates now. Whoever has the first contact pays, and then the payment is sorted out later as between what levels of government. And so I have heart that Jordan's principle will be fully implemented under the Canadian, the new Canadian approach of settling under the class action lawsuit. Plus, there is new legislation from the federal government. We call it Bill C-92, an act respecting First Nations children, Inuit and Métis children, that provides for First Nations communities to reclaim, restore, and rediscover their Indigenous Debludans in regards to, in most places would not say child welfare, they will say child health and wellness. So that's what they're looking at here. So and as part of that, there will be significant aspects of Jordan's principle to provide equitable health care for anyone that needs this, regardless of on or off reserve. And that's it in a nutshell. I hope I answered the question in the chat. I know, it's a snapshot of what's happening. So,
yeah, thank you for that, Tuma. So I think we've been touching on aspects of this question throughout. This whole question about how the wisdom that comes from two-eyed seeing can allow us to imagine a different future state of human rights in Nova Scotia. And so we've talked a little bit about all new law becoming more part of the fabric of human rights. We talked about language being a big part of it. This notion of thinking even beyond rights being held only by humans, right? And the relationship between humans and the land and animals. So kind of pulling some of those threads together, I'll just kind of ask that question that's at the core of the discussion today. And John, will come to you first, and then Tuma, maybe you can answer the same question. So how might that wisdom that comes from two-eyed seeing, how might it allow us to imagine something different, a different future state of human rights?
Very important. As the work we do with the Wabanaki Two-Spirit Alliance, for example, and looking at the rights of our young people and youth and people who self-identify using terms that have to do with 2SLGBTQQIA+, two-spirited. We understand that if we have reconciliation, not only with the rights of people, but the rights altogether of that kinship around who we are as Olnu and our relationship with our surroundings, our ecosystem, and with kinship within the treaty rights with other folks in our region, that's an important strategy for us in building and reintroducing and re-educating people who have been impacted by very colonial perspectives around what gender looks like, what sexuality looks like, what our spirituality is about, what our laws being Indigenous, Aboriginal, Ulnu, and even two-spirited identity are about. And so that's important that we look at. Tuaitsin has helped us, Etuaptmumk has helped us, to look at our historical ancestral perspectives and knowledge. Most importantly, our primary source of knowledge from an Ulnu perspective has been, a foundation of what we believe and the principles of how we act with people and other surroundings around us, which then we take that and bridge it into how we relate to them through respecting identity. You're respectful of identity as a two-spirit person, reintroducing the language that had been impacted that talks about who we are as two-spirit people, reintroducing ceremony, traditions. We've seen, for example, in the debate around 713 policy in New Brunswick, that it's how people can or cannot express their identity or use their preferred pronoun or their preferred name. We always gave our children a right to represent themselves and how they feel is best for themselves based on our principles of the sacred gifts of love, wisdom, truth, faith, those ways of identifying yourself, because you have to really be respectful and come from the principle of your beliefs and traditions to act right. And if you are able to understand those principles through our language and our ceremony and the way we are as two-spirit people, then we are validating their identity, we're validating their sense of belonging to the cultural fabric of our identity as well as a nation. Then that is the inherent way of being, which exemplifies your right as who you are, and in relation to your surroundings with the others. So if we continue to, principally pass that knowledge down, and it's inclusive of being two-spirited, then we're being in the right path of reconciliation. So that's what we have to look at, that, there's a way of looking at the current contemporary perspectives on human rights. We recognize those are valuable. We recognize our ways of being and knowing and who we are as Indigenous people, Ulnu, and then within the fabric of that identity, making sure that two-spirit people are included in there culturally, ceremonial, and everything else through education. Then we are able to then, provide a person who's young a more wholesome way of understanding their surroundings, which is more representative of who we are in a contemporary world. And that's important. We can't just reduce it down to like a Western-based framework, because we come from also the Ulnu thought processes and that Etuaptmumk way of looking at everything. So we have to work towards that and make sure that we continue building that pathway so that they continue to, Elder Albert said to me the other day in my study, he said, you're not harvesting this knowledge only for your nephews and nieces and your grandchildren or your future family's great-grandchildren. You have to look at it from the aspect of being able to have this harvested in 800 years from now. And that really opened my eyes. And I said, listen, we have to look at it that way, because, for example, and he gave this solid example, when they started harvesting knowledge around who we are in identity and spirituality beliefs, and they interpreted the Bible 400 years ago, that's knowledge that's still being used. And we're in the middle of that cycle, only at the middle of that cycle of using that knowledge. We still have 400 years of that knowledge that we can still use. And so we're harvesting that knowledge, making sure that we make those pathways solid for, better futures. And that's how it's helped us put a framework around what that means then. And human rights is only one aspect of it, but it's not the all-encompassing part to it. We have to expand that knowledge way of looking at it. So that's very important to us.
Thank you, John. Tuma, what about you? What would you say if we kind of pull the threads together and just try to address that question head on? How can the wisdom of two-eyed seeing help us to re-envision how we do or how we think about human rights work in Nova Scotia?
Well, by bringing in the Ulnu concepts of human rights and responsibilities to the work we all do, will drastically improve everything. I fundamentally believe that. And it's just a matter of how creative we're going to be in creating these institutions and how they were going to be working. For example, I like to tell stories, and I'm going to tell you a little story. A number of years ago, when I was starting to do I think somebody said that they posted this song on the Member Two website of what's the name, Mr. Christmas singing, and he was the chief of the Member Two Reserve in there, no, during those days, and he was talking about the marriage song. Now, I had just recently been appointed as a justice of the peace for Nova Scotia, and I was very interested. Okay, what's the marriage song? So I listened to it, and because I'm a fluent speaker, I could understand what he was singing about. And he talked about the institution of marriage, and he talked about before the Anglo-Saxons and the Wendish came, before the French and English came, before the settlers came or the colonialists came. He said, we were able to marry folks, and this is how we did it. There were some rituals, there were some songs, there was consent, there was, etc., choice in the whole matter, and feasting, etc. And then there was groom service. And then after the groom service, there was confirmation of it. The whole process of validating the marriage took over 1 year, and that the community was substantially involved. And then the second part of that song, he said, after the groom service was done, and then they came back, they had to report. There was accountability too, back to the community. They had to report back to the community whether the marriage was successful or not. And if it was, they had more feasting, more more partying, etc., just like what we do here, reception, I guess, but there was also a report back if the marriage was not successful. And then they sang their marriage dissolution song. And that they were saying it. And I remember listening to the song, and I'm like, oh my God, that's my cousin Joey. He used to sing that song when he had a few beer in him and we're down at the beach, on his guitar. I thought it was just more or less a drinking song, I mean, come from Cape Breton, that's what we all do, right? Anyways, but and I said, oh my God, he's saying that if they are not happy, we are not happy, we are not happy, we are not happy. And so as such, they reported back to the community. And once they finished their song, both of them were able to go back to their family, and both were free to marry again. And so under this, we almost had the Bludagan or Mi'kmaq law on the solemnization of marriage, which is currently a provincial head of authority. And we also had the dissolution of a marriage or divorce, which is a federal head of authority, lawmaking authority. And they were combined, but it was all within our institution, and this is how you had to do it. So today, when I do a wedding, I have to follow the Marriage Act of Nova Scotia. There's special words and phrases that you have to use, the oaths and witnesses and stuff like this. But at the end, I say most of the time, when people say by the authority vested in me under the Marriage Act of Nova Scotia, I now pronounce you to be spouses. I don't say that. I say by the authority vested in me by under Ulnuek Debludahan, I now pronounce you spouses. I marry them in accordance with Mi'kmaq law. No. And I register it. They know that the province, and they said nobody has ever said anything with me or anything like that. So now I think, how can we do this within the existing systems that are in place? For example, the Nova Scotia Human Rights Commission. You can use the Nova Scotia Human Rights Act as one of the grounds of protected areas. But if we were to bring in Ulnuek Debludahan, and what are the grounds that are prohibited under that, and to expand the range of grounds. And I think I heard recently that you guys reread my report that I did to Nova Scotia Human Rights back in 2006, 2007, I think, with a few others. And we talked about how the perspectives of Ulnus living in First Nations communities, some of their grounds of discrimination do not fit in well with those list of categories, either under Canadian human rights or Nova Scotian human rights. For example, some people feel that they're discriminated against by virtue of their family status. And when they say family status, they're talking about whether they're considered a clan. They're discriminated against the clan. They say we don't get equal services from the band or from the education system because we're considered to be less than, or this clan is not as high as this team or something like that. So they feel that because I belong to this family clan, we're not getting equal services. So, but that's not a protected area, or ground of where you can look. But under Etuaptmumk, it is. So bringing it in, you can expand the ground and bring in more, and it's familiar to folks who are considered two-spirited, or I like to use that acronym. I know LGBTQ. I shorten it, or not. I don't shorten it. I say LGBTQ. That seems to work for me, right? LGBTQ, two-West LGBTQ, and you think about it, how we perceive ourselves through that. Some of those areas may not necessarily be grounds for complaint, analogous grounds or discrimination, but under Etuaptmumk, they would be. And so when you were looking at treaties too, there existed early on in the early interaction, there was a middle ground approach that Etuaptmumk would be applied in these areas, and also Western law or colonialist law, but neither would dominate. And they would create this middle ground that would exist to resolve these interactions, these spaces, these legal spaces, or these legal worlds where both, the British or the French would interact and the Mi'kmaq would interact, and they would create a hybrid middle ground where both were successful or both benefited from it. So looking at it from that perspective, if we were, the future work of human rights processes and discourse in Canada, Nova Scotia, Mi'kmaq communities or Innu communities, and at the international level, we need to bring in international, not international, but Indigenous legal understandings of human rights and their processes and their responsibilities to those areas, so that we can create this, whether it may be a hybrid approach, a middle ground approach, that I can see only will benefit and increase, better outcomes for everyone. That's how I can see it.
Thank you for that, Tuma. John, I want to pick up on something, a point that you kind of started, and then Tuma built on it a bit. And so it's using the acronym, right? The three of us would identify as part of that 2S LGBTQ plus community. And I know, thinking about my own experience with the acronym, right? And trying to figure out as a young person which letter I am, or was my letter there, or maybe I was a plus sign, or more importantly, why do I have to pick a letter? Like why do I have to identify with some aspect of this acronym? And for me, eventually I came to embrace the notion of queer, which is just it's simple and it works for me. And I think about that as being somewhat similar to the notion of two-spirit, right? I can't identify as two-spirit. I'm of Western European ancestry. But it feels similar. And when I think about my experience of trying to figure out where in the acronym I fit, and that's kind of a dehumanizing experience. And I liken that in part to this notion of a list of protected characteristics, as Tuma points out, right? So when an individual comes to interact with our human rights framework, their starting point is to look at a list of protected characteristics and pick which ones apply to them, so they can then demonstrate or prove that they've been treated unfairly. So there's this compartmentalizing of identity, right? And to Tuma's point, do we even have all the right characteristics listed? So I'm just curious about your thoughts on this notion of compartmentalizing identity and the way people need to come into interaction with the human rights framework through that kind of a process or experience.
Yeah, and I noticed someone's question also saying, what are the challenges of applying, for example, Etuaptmumk? And I'll add two things to that. First of all, the problem with the Western world trying to analyze indigenous ways of knowledge is that problem of categorization, classification, trying to put and compartmentalize like our way of understanding the world into a Western framework. So we want to, you know, put it as a theory, as a framework, or is it a methodology, or is it not a methodology, you know, that kind of thing. And in the literature, in all of this, looking at Etuaptmumk, people look at it from those frameworks and they get bogged down with classification of that when we don't classify our knowledge that way, first and foremost. And so that's one of the challenges is the Western idea of they have to accept what Etuaptmumk is through publications and through, you know, practice and through legal practice, and then, you know, getting to that point. Human rights are anchored heavily on legal frameworks, first and foremost. And so, and they're very Western based. That's only one part of the world. That excludes the majority of the world's knowledge and sources of, you know, their worldviews. And the other thing is that when we come to identity, who's to say we can only use words? We have communication that we've seen. For example, our if you look at the Two-Spirited in our organization is called Wabanaki Two-Spirit Alliance. Our symbols are Jijamishk, the two symbols that are you see on there. Jijamishk symbol, and I analyze it and talk to elders about what Jijamish means and how that represents the identity as a person. And the identity is a symbol that's ungendered. So it's a round symbol. It has a, you know, like a circle in the center, and then it's founded on, you know, a stem that's got a foot to the world. And then it has three prongs in the top that reaches to the, you know, to the spirit world and the creation, you know, it's part of the creation world altogether that says in that symbol, the importance of your identity. That's not a word. So we recognize that through communication, that that's who we are as two-spirited people, that we are part of who we are as Ulnug, and we understand that through our collective experience and knowledge and consciousness. Now, should we have a word for that? Sure, we could come up with a word. And that's what Tuma is a prime example of always coming up with words. He has an encyclopedia of vocabulary around birds and looks at the traits and characteristics of a bird or what the bird does, and then puts a word together. And then elders look at it, and if it makes sense to them, and if someone wants to contradict it, they can, and they can challenge it, and we can do that. And so we have words that are being brought forward that not necessarily coincide with 2S LGBTQIA+. You try to say that 3 times, you know. And so when we're writing, for example, I use 2SQ+. Just to, you know, minimize the writing that over and over again. But we fall too much on the word to make your identity, rather than to understand identity as part of an ethnic and cultural and linguistic identity. So that's more important to me than just a term itself. Too many people claim terms to be their identity, rather than, it's a representation for sure, and it's a way of communication, but that doesn't necessarily give you who you are. We always said that we're Ulnug or Ulnu, the person, like the squeegee, like the human. And so Ulnu and then Ulnu, the collective, you know, people that speak the same language. That's our first anchoring identity of who we are. Then we come to understand that through gendering, sexuality, our relations with people, we come to our identity, and we fulfill our identity eventually if all things around us is balanced. Then we become two-spirited. We come into that identity. And there's a word that elders had shared and knowledge holders that said, debabueg or debabueng is like coming into who you are in a balanced state. So I really, it made sense to me that we could use our language and understand that there are different stages of your evolving identity that may take on different words, but it's still, you're still Ulnu. That's your anchoring identity. So that's the most important thing that we have to reteach our, you know, youth and young people. And then with that, then we, you know, come with these new terms that we can help them with. And so that's important as well. And the challenge with Tuaitsing is that people are always trying to fact check what Tuaitsing is, because they try to say, what is it? Who's it come from? What's published knowledge around it and everything? When we represent Etuaptmumk of knowledge that comes from foundations of epistemology, science, history, and knowledge of our world from a scientific worldview that's thousands of years old. It's not just something that, you fact check in Google and then publications come of it. And Elder Albert published these papers with Cheryl Bartlett, for example, or Merdina with other people. So, that's the challenge, is that then we are put into a situation where we have to validate our own knowledge, where we come from. And I say in my paper to my PhD dissertation that we shouldn't have to do that. I have every responsibility to validate the knowledge within our own elders and language experts and linguists and knowledge holders and experts like Tuma. That's where I validate that knowledge. I don't have to validate it in the Western sense. So that's part of the challenge, is making sure that people understand that we have our own process to that. And that worldview of knowledge that we have can contribute to a whole source of knowledge in human rights that can expand on a very wholesome understanding what that stewardship is from our perspective. So that's important.
Thank you for that, John. We do have a question in the chat. I'm going to put this one to you, Duma. It's a long one, so I'll read it aloud, and we'll get your thoughts on it. So the question is, rights often play this powerful role in challenging injustice and opposing oppression, along with animating a vision of a more just future society. However, they are also used by states, etc., as weapons against Indigenous rights, prioritizing property rights and citizenship rights, with the 1969 White Paper proposal, for example, as a way of trying to deny or erase treaty rights, land rights, self-determination, Indigenous sovereignty, etc. Can we begin to get past this political rights as weapons dynamic by expanding our understanding of rights, along with challenging limited Western notions of rights?
Well, that certainly is a mouthful, that's for sure. And I have to think about how you, Jeff, you're absolutely correct on that. Rights have been used to advance and make life better for most folks, and especially in oppressed communities or marginalized communities, or for communities who are able to utilize them, but often within an individual rights discourse. And then also at the same time, these rights have been used to keep folks down and keep things. I'm thinking about where the roots and the sources of rights can be thought about. For example, many of the things that you mentioned as a way of, like, for example, 19 White Paper policy, treaty rights, to erase treaty rights, land rights, self-determination, self-indigenous sovereignty, they're all kind of rooted back, if we go back into the history, about the intersectionality between institutions, between, like, for example, the religious institutions and the governance institutions. And that intersectionality still operates today. Much of these rights, or the processes for erasure of collective rights of Indigenous peoples all over the world, are rooted in power and power over. For example, in 1400s, there was these, you might have heard about these, the papal bulls that were enacted by the Pope. In some ways, the history of Europe is also the history of the Catholic Church. It's a very, very familiar thing. So you had these papal bulls, and how the crown used to assert their inalienable right to govern over, or to have sovereignty over, rested in, we received this authority from a higher power, a god, a religious entity type of thing. And this was confirmed or delegated or designated by the Pope, in these papal bulls. And these papal bulls were used as a source of international law previously. and that these were used to advance what these doctrines of colonization were. There's a number of these doctrines of colonization. For example, doctrines, the most famous one is the doctrine of discovery. You know, we came, we found, we discovered, you know, this, and that's in that name we claim in the name of the crown of France, in the name of the crown of Britain, in the name of crown of Portugal or Spain, whoever it was, the crown, or even many other areas. So you have to, but there's other doctrines of colonization, the doctrine of terra nullius. We still have it, which means that the doctrine was described as, well, there was nothing here. And this also played into how the perception was there was nothing of value here that could be used. Now, we all know that's not true. There was a lot of minerals, resources, timber, etc., type of thing, a lot of active resources that were clearly valuable, but they were looking at it like Indigenous people were not farming or using the land to the best advantage like we do in Europe or something like that. Or that, and even the French, when they arrived in Louisbourg, and they would bring over plants that they were using medicines because they said there was nothing here that would be useful in terms of plant medicines. You know, and that's why we have a lot of invasive species that there. And so that's the doctrine of terra nullius. And that was used to justify the colonization of the land. Now there's others, you know, the doctrine of conquest. We came, we conquered, we took. And that in some ways that applied to conquered lands. We know what's that famous phrase? To the victors is the spoils, right? But if you look at what happened in Europe with World War I, World War II, and various other wars, those countries kept their territorial integrities. You know, Germany was defeated twice, right? No, but kept, you know, became still was Germany. Korea, etc. So Korea, North Korea, Vietnam, all these major conflicts all over the world. These doctrines of conquest is not really applied there. You know, in some situations they are, but they really were used as a tool of colonization. And along with these, the rights. And one of the historical ones that I can think of was called from the Spanish and Portugal, the crowns, which, especially the Spanish, they required, the Pope required them to issue a requirement. It's a requirement before you would go and step foot on or claim the land in the name of the Spanish crown, or in the name of the Pope, actually, was that Spanish captains would be required to read out a little proclamation saying that to the inhabitants of these said lands, if you are Christian, then you're obligated to submit to the Christian crown, etc., type of thing. And as such, if you submit to us as a Christian, then your lands will be considered as part of the dominion of whatever crown it was. Well, in this case, was Spain. And if you were not Christian, you're considered heretics, or, you know, one of these folks who did not believe, then they would be required to make war upon you if you did not convert. And of course, then the war would, you know, result in the doctrines. So rights were used, and even the international, this was kind of the international rights discourse, were used to justify colonization. These doctrines were later incorporated into law, and they're operating in the law as we speak of today. For example, the doctrine of discovery was incorporated in the United States through the Marshall Trilogies, and in Canada, in the case of St. Catherine Milling in Ontario, you know, back in the 1800s, right? And so, despite the fact that you would have the Pope just recently issued an apology to residential school folks, and also denounced the doctrine of discovery. But under Canadian law, the doctrine of discovery was incorporated under St. Catherine's Milling. So it's still very much a live function there. And the same thing with rights. Human rights have often been used to continue that colonization principles. You know, and under the guise maybe that we are trying to make things better, but in doing so without proper acknowledgement or incorporation of collective rights or the Indigenous institutions of rights, or the understandings of rights along with the understandings of obligations, that you get the result of the Western or the states human rights being imposed, and not working together on that. So in some ways, that's in a short nugget, I can try to answer. I hope I try to answer your question.
So interesting. Thank you, Duma, for that. We do have another question in the chat. John, I'm going to send this one in your direction. This might be the last question from the chat that we'll have time for before we start to wrap up. So this question is, from your experience in applying two-eyed seeing, what are some of the challenges that you can point to or that you've encountered, realizing that we're bringing a principle that's rooted in Indigenous knowledge into a highly colonized system?
Mm-hmm. Yeah, I began to allude to the question already by saying that in the academia, for example, in publications around two-eyed seeing, they wanted a validation where this knowledge source is. And a lot of the Indigenous knowledge we have, of course, comes from Elder Albert teaching us, Duma sitting down and teaching me about this stuff, and sitting down with our elders. And so our understanding of our knowledge is a continuous training that's intergenerational and ongoing, and reapplied in contemporary ways. In this case, looking at Two-Spirit and what is Two-Spirit using Etuaptmumk. It's not a new way of looking at the world. It's been a way of looking at the world that's always been there, that we've used. But for it to be validated, I have to publish a paper to discuss how that is, which is part of the challenge. I don't have that obligation if I'm in my community, or if I'm talking to Duma, or if I'm talking to elders in our community. We have that discussion. But if we have that discussion outside of our community, then we're obligated to address those verification or validation of that knowledge source. Fair enough, we do it anyway. We validate our knowledge all the time by saying, I got this from Duma, Duma got it from their mother, it goes on. We validate our knowledge all the time in our way of doing things and our relationship ways of doing that. So we don't mind sharing that. It's our way of doing it. It's just, and we're accustomed to doing these publications. It's that nature though, it's that sense of entitlement that the Western academia has to actually challenge our knowledge sources, our worldview, our way of explaining the world around us, our worldview around what human and rights are. But again, we expand on that perspective, of course, by making sure that we address and share knowledge around how we look at what rights are, not only from what I tease around saying a reductionist view, just looking at it from a human right. But that's valuable insight, I think, from outside of our communities, that people understand that a little bit. So when we use Etuaptmumk in the publications world, we're ready to understand that there's going to be people that challenge that or don't quite get it because they've only been trained in that sense. And I'll give you a quick story around that. I do pediatric pain research at IWK with the Children's Hospital. And we've been doing pediatric pain research in our region sometime for 15 or 16 years. And we've collaborated on knowledge building around understandings around pain management, pain assessment, and communication around pain from a Western perspective, also from a Olnu perspective. And then we've used Etuaptmumk as a way to, teach this. And I was presenting on our pain perspectives at a presentation in a conference, and when one of the pain specialists, really renowned in the world, had asked me, where's the validation of this knowledge? And I said, well, I am explaining the validation of the knowledge. I am sharing what our own have been telling us, and through art and through oral tradition and through stories and those narratives, we've collected this understanding that pain and the perspectives around pain say this. Yes, but where is the quantifiable clinical data? And I said, that is the data. So we're going back and forth and debating this. And I finally said to this individual, I said, well, really, it's not your fault that you have a deficit understanding of what pain is. You've been trained under a Western perspective that pain to you is a threshold between 1 and 10, you know, a number from 1 to 10. That's a perspective that you understand. That's what you've trained and paid your university knowledge to let you know that that's what pain is. I'm letting you know that we understand that, as well as the Indigenous component of what perspectives of pain around are. And we have thousands of years of knowledge to understand what that is and how we communicate it, or how we even understand when a person is in pain without having to say that they're in pain. And so they were looking at me and I said, well, but that's not your fault. So I turned it around and flipped it on them, and they were just, they must have thought I was crazy to say that our Indigenous knowledge, which I consider our primary source of knowledge, first and foremost, to understand from our worldview what that is needed to address that pain, and then come in with the clinical understandings what pain is to treat that person, and use Etuaptmumk to treat that person even better. And so to them, it was very bizarre that I would say that, and you know, and I thought it was bizarre that they would only think that I only had one source of knowledge. So, but they came afterwards and they said, thanks for challenging me on that. I didn't really look at that from that view. So it really was a aha moment for both of us. We said, hey, we don't communicate pain in the same way. We don't even have a word for pain in Mi'kmaq. So we understood that, and we had to really look at that from a very different way. And from then on, then we understood how we can start looking at ways of increasing the understanding of pain and how it's treated for Ulnu children in Eskasoni, for example. And we're doing that now. But it takes a long time to understand that process because people doubt our sources of knowledge. And that's part of the entitlement of the academia. So we have to make sure that we build that relationship so that they understand it. We have to take the time to explain it and share it, and not share some of the other things that we don't want to share with you. And so that's important as well, but respect that. And so that's part of that treaty relationship we have to rebuild quite often. So it'll happen. We're getting there better and better. And it is a process. Thanks for that question.
Thank you for that,
Yeah,
John.
and if you don't mind, I'll just jump in a little bit there. And in some ways, what John identified is clearly, you know, how knowledge is created and valued and, you know, and brought forward in the Western context. You have to do research, you have to publish, you have to, you know, once you publish, the more it's cited and stuff like et cetera, and then it becomes more and more the truth, you know, type of thing. And he identified a deficit of knowledge here. And in some ways, the future of Human Rights Commission, I'm going to bring it back here, is that there is a deficit of knowledge here, you know, as to what Ulnu Debludan is on the Kokwajadi Gemkoel, you know, our human rights. And I know that in the 80s and in the 1990s, there was a huge discussion among Indigenous academics about human rights discourse, individual rights and collective rights. So that this intersectionality needs to be supplemented. And I think John Morris, you know, made it very clear. He says, just because we have collective rights and that these do not necessarily kick out individual rights. They're subsumed in that. They may be given equality in it, but you have to, you know, think about, you know, human rights, not just from an individual rights discourse, but also from a collective rights discourse. And in that sense, you also have to expand out of just what is the Human Rights Act contains, the grounds. And I would imagine, and let me just run this by you, Joe, and everybody else, that probably a lot of discrimination complaints coming from folks or communities of color are in the workforce. And so many people might see this as a labor issue and even if it's perceived in a labor context, or the complaint goes through that, whether it's in the collective bargaining process, people of color or communities of color would see that as it's not just a labor thing, it's also a human rights complaint. And so I would think that may be a possible deficit in how to handle these type of intersectionality claims or the perspective of claims would be a little bit lacking from within the Nova Scotia human rights tribunals and also maybe in the labor tribunals. That perhaps there is a way to bring them all together to see them from the complete picture, and that's what Etuaptmumk means.
Thank you, Duma, for that. Look, thank you both. We are just exactly at 3:30, which is our end time. I hate to end the discussion. I have to thank you both so much for the generosity in sharing the wisdom and perspectives, and in particular the sharing through story. It's been a wonderful conversation. So thank you, John Sylliboy and Tuma Young, so much for joining us, spending this time with us, and for sharing your knowledge with us. I want to also thank Jeff Overmars and Ayo Oladejebi for their work in the background to coordinate this event. The recording of today's discussion will be available on the Human Rights Commission website and also on our YouTube channel. Thank you also to our ASL interpreters and for everyone who joined us this afternoon. I hope that you've really enjoyed the discussion as much as I have, and also hope that you were able to take in other aspects of our Human Rights Week programming. I hope that everyone has a safe Human Rights Day, wishing fairness and equity to everyone, especially today, but every day. Thanks so much, everyone. Namoltis.
Muchas.